Ms. Nacon, which
Yes.
is the 3 years versus indefinite leave.
Yes.
Now, her submission was actually to miss the point, because this distinction was of no materiality in the context of biometrics. Is that right? Is that the correct submission? Is it irrelevant that it's 36 months, Blaze, indefinite leave?
No, it isn't irrelevant at all. If a measure is temporary, then the level of checks and security that you might need to enable people to come might correspondingly be slightly less than if what you're doing is allowing people to arrive and settle. Having said that, it's not the most weighty of points in relation to the waiver of biometrics.
Right.
So, at the stage of developing the policies for Ukrainians, it was anticipated that people would apply for entry clearance and they would have to provide their biometrics. And this all changed in March 2022, so obviously quite soon afterwards. And that's explained in the witness statement of Mr. Burt at paragraphs 10 and 17 through to 19 on page 45. And you'll see at paragraph 10, it specifically says, second sentence down, the decision to allow some Ukrainians with valid international passports to come to the UK before they had provided fingerprint biometrics was made exceptionally as a temporary measure to ensure visa application centres, VACs, across Europe could focus their efforts on helping Ukrainians without valid passports, some of whom were very vulnerable. This decision was made to ensure that VACs across Europe, which were not designed to cope with a sudden and overwhelming surge in demand following the invasion of Ukraine, could focus their efforts on helping Ukrainians without valid passports, given the sheer number of people fleeing Ukraine. The pressure on VACs would also severely disrupt normal operations for other nationalities who are required to attend a VAC as part of the visa application process. And you'll see again at paragraph 18 and 19, we introduced these provisions for Ukrainians on a temporary basis to ease the pressure on our VAC network and facilitate early travel, but not for Afghans or any other nationality, because the security assessment of those coming from Ukraine permitted a temporary lifting of the requirement and is very different to the overall security assessment in relation to Afghanistan. We are able to approach the Ukrainian government to verify what passport issued by them is genuine, which is not an available option with regard to Afghanistan passports and the Taliban. And then paragraph 19 sets out the risks posed from Ukraine, were primarily around immigration control, with some security risks associated with the proximity to Russia. And then further down in that paragraph, by contrast, Afghanistan poses both immigration and security risks, which are of a very different potential to Ukraine, and this has been the case for a long time. There are several terrorist organisations which have operated from Afghanistan and continue to remain there, such as ISIS and Al-Qaeda. So the question is whether anything in the new material, the more recently disclosed material, adds to or changes that picture at all. And in my submission, the answer is no. So if you go to then the 10th of March submission, which is at page 7 of the second supplementary bundle. Sorry, it starts at page 6. And you'll see that paragraphs 1 and 2 head on are reflected in what I've just read to you from Mr. Burt. which is you, the Home Secretary, paragraph 1, have asked for proposals to more quickly process applications from Ukrainians seeking to come to the UK following the Russian invasion of Ukraine. This is to relieve some of the pressures on our VACs. The launch of the Ukraine scheme route and its further expansion to include wider family members, as well as the imminent launch of the sponsored humanitarian pathway, mean we are unlikely to be able to keep pace even with planned increases in capacity. And there's and then it goes on to explain about biometrics. I think a lot of these passages have been read to you, and I won't go through them. But paragraph 3 identifies the discrimination risk, but considers that the proposed direct discrimination is necessary and proportionate because of the unprecedented circumstances forcing people to leave Ukraine and need to respond quickly. Paragraph 12 on page 9 identifies amongst the reasons not to introduce the concession, the impact on public perception on the government response to safety and security, and the potential for arguments that it should be extended to other persons.
But I think sort of the way, I'm not doing justice to the fulsome way it was put, but I think what's being said here is that none of this sounds as if it is ruling out any risk, any legal risk at all, and therefore the weighty reasons in favour of doing it aren't, or the reasons aren't very weighty. And we see in all of these submissions there, you know, the recognition of arguments that this isn't necessarily proportionate, fair, or whatever. And what's your response to that headline point as I see it?
Yes, the response is straightforward. It would be absolutely normal for advisors in this sort of document to flag up risks with taking any policy. And it was completely correct and on a precautionary basis to implement a ministerial authorisation in order to do that. But if you read this document through, and if you look at paragraph 17 as well, which refers to humanitarian crisis and geopolitical considerations, HSG, that's the Homeland Security Group, have made an assessment of the merits of different security checks against the current threat assessment from terrorism and hostile states. A separate high side note is available. However, direct comparisons with pitting is not appropriate in their view. I mean, that's not a legal assessment one way or another, that's just the view expressed. And you'll see subsequently in the 23rd of March, there's a reference back to this security assessment, and there's more detail given about it. But the point is that the reason for doing this, for waiving the biometrics, was having decided to have the Ukraine policy, it then became clear that there was going to be millions of people flowing across Europe, as indeed was the case, particularly through Poland, that the VACs would be overwhelmed and it would be impossible, effectively, to implement this in a meaningful way. And so the question was, well, what do we do so that we can give effect to this policy and not overwhelm the visa application centres, who also have to deal with other categories of people for whom you can't waive or may not be able to waive biometrics, such as Ukrainians without passports at all.
So impossible to implement the UFS or
Well,
Ukraine.
maybe I put that a bit high, but it would certainly create a massive blockage on the implementation of the policy.
Well, it would be. There was no plan by which you could do millions of biometric tests.
No, well, obviously not millions wanted to come to the UK, and nor did they, but there were millions of people flowing across Europe and who were trying to get to various places, and we know from the figures that I think well over 100,000 or 200,000 came here. So the existence of the US as a scheme is not actually is not under challenge, because of course the Afghan scheme has its own scheme, right, which is different and in some ways more generous and in some ways less generous. But the focus has been on why the biometrics were waived in this case in relation to Ukrainians. And the answer is there were two things that made it that are different from the position in relation to Afghanistan. One is you had a massive migration of people across Europe, or within the Schengen area, who could all flow through, and the VACs would, the visa application centres would be overwhelmed, and that it would, and that as a result, people would not be able to benefit from the decisions that have been made to accept Ukrainians, but also nor would other people be able to use the visa application centres who had nothing to do with Ukraine, and it would also not enable people who didn't have a passport at all, for example, who had to attend one anyway, to do so.
Sorry, so you said two things, forgive me, two things were different. Massive migration, overwhelming VACs, and linked to that, is that the second point? Other people, non-Ukrainians, would not be able to benefit from the VACs because they'd be overwhelmed.
That's right. I mean, it would create an impossible blockage. And what you have to recall, of course, is that the scheme that was the underlying substantive scheme, if I can put it that way, there were all sorts of important macro-political, if I can put it like that, reasons which set out in Lord Carlisle's statement, Mr. Carlisle's statement, as to why that scheme was brought into being in the first place. So then the submission of the 23rd of March, which is at page 16 of the supplementary bundle 2. So this was the submission about providing a biometric waiver to not only people who had a biometric passport, but also those who had an international passport that didn't have a biometric chip in it. And the reason for that extension is set out in paragraph 2 on page 17. We want to extend the AUK, that's short for Access UK 2 process, to holders of valid Ukrainian non-biometric passports, which would enable more Ukrainians applying to one of the Ukraine schemes to use that route when applying from overseas. We understand that only around 5 million Ukrainian nationals out of a population of around 43 million hold biometric passports, and so without this change to the process, many would need to continue to use the current biometric deferral process, attending a UK VACs in the UK to provide biometrics. And then at paragraph 5, you will see that it says the Homeland Security Group and UK intelligence community acknowledge that a removal of the biometric chip verification affords opportunities for people to attempt to travel using counterfeit documentation or false identities. However, they consider that the mitigations being proposed, coupled with the wider threat picture from this cohort, means the risk is manageable. And then paragraph 6 refers to the classified information note, which was referred to in the earlier document, and it says that that advice is also applicable to this submission. And then again, once again, you get risks set out in the submission, such as those set out in paragraph 12. And then paragraph 13, we intend to apply to Ukraine nationals temporarily. We intend this to only apply temporarily. Then finally,
But the important point that I
yes.
taken from this was the paragraph 5 point, which is that you can do some, you can think about waiving, and that's a balance. You've got mitigations on, but what you're really looking at is the threat picture from this cohort. It's specific to this cohort.
Exactly.
In this cohort of Ukrainians, we think it's a manageable
Yes.
concept. And obviously for us to decide where that leaves us, but that's the reason.
Yes, exactly.
Thanks very much. And then picking up the theme that I raised earlier, paragraphs 11 and 12, well, the submission put crudely as well, it doesn't sound terribly confident. Position will be harder to defend as Afghan families will request we provide them with similar treatment. So, says the appellant, where are these very weighty reasons? And your response to that will be the same as the one you gave me earlier.
And these are perfectly weighty reasons.
Yeah.
These are in my submission. And we'll come to what exactly I have to justify, which is the difference in treatment as opposed to I don't have to justify this policy. But yes, again, I mean, I'm sure members of this court have seen many documents along these sorts of lines. There's nothing surprising in them. They're a little bit warts and all. Yeah, there we are. So then the submission, then finally the 8th of April submission, which is at page 24. Sorry, just before we get to that, could I just show you on page 20, that's just the end of the earlier submission. Yeah, paragraph 22 is another reference to arguable direct discrimination on the grounds of nationality. So, you know, it was accepted and it's repeated throughout all of the submissions that it either will or is an arguable, involves arguable discrimination on the grounds of nationality. I'll come to the importance of that shortly. But finally then, just the 8th of April document, the overarching point about this is that it doesn't really take matters further, but simply reaffirms the reasons for the policy that was already set out in the earlier submissions. And with paragraphs 5 and 6, just set out the litigation context, and it's your point, Lady Justice Carr, but again, none of that. It doesn't change the rationale of the policy as set out in the previous submissions. Now, this 8th of April document is actually quite short, and it doesn't fall to be read on its own. If you look at on the front page, page 24, there's reference to Annex A, the ministerial authorisation, which was obviously disclosed before. Annex B, the equality assessment, and 2 equality assessments, B and C. Now, those were disclosed as well at the time before the litigation, and they appear in Supplementary Bundle 1.
So we're on the EIAs, are we?
Yes.
So give me the reference again, please.
Yes, I'm just finding the reference. There are 2, and the relevant one is, they're both dated the 8th of April, and the relevant one is Supplementary Bundle 1, page 163. Now, these documents, as I've said before, they were disclosed in response to the request for further information, and so were before the judge below. And the point really is this: you get a much more detailed summary of the policy in the background in this document on pages 163 and 164. Over to the top of 165 than you do in that submission of the 8th of April. And I'll let the court read it, but basically all the paragraphs under heading 2 on page 164 explains once again that which is exactly contained in Mr. Burt's witness statement. And is not, and in any event was in front of the court below. And you'll see in relation to the security assessment that that's dealt with in the 3rd paragraph, the bottom paragraph on page 164. The last sentence on 164, this change has been made on the basis of security advice around the Ukraine scheme, which allows us to make this change safely, as well as the need to process an unprecedented volume of applicants and the need to respond very quickly to the ongoing crisis in Ukraine. We will continue to carry out vital security checks on all cases based on biographical data contained in their passports. And then the final paragraph, Ukrainians who hold biometric internal passport, identity cards, and do not have valid Ukrainian international passport will still need to attend a VAC in person and provide their biometric information. So,
Going back to
yes,
page 164,
yes,
the last passage before paragraph 2 summary.
yes.
This is intended to be a temporary arrangement which will be reviewed, etc. It says it involves direct discrimination based on race. So did
Yeah.
they mean that or nationality?
It should be nationality.
Yes.
The just for completion, but I don't think you need to read it. The other inequality impact assessment is at page 151, and that's to do with the approach to Ukrainian illegal or irregular migrants. But I don't think it adds anything was previously disclosed. Nobody's made anything of it, so I don't ask you to turn it up. In conclusion, we say there's nothing inconsistent with the summary contained in Mr. Burt's statement, which shows that the problem being identified was the overwhelming of the visa application centres in Europe by the mass migration of people fleeing Ukraine. And this was a problem not only because there was a need to give practical effect to the policies contained in the Ukraine scheme and the Ukraine Homes for Ukraine scheme, but because of the sheer numbers would mean that others who also use those centres would not be able to get appointments to all their biometrics. And the solution that was adopted was to suspend the requirements for biometrics to be taken in advance, albeit not in fact for everybody because it did vary a bit. And it's clear from the witness statement and the contemporaneous documents that one of the concerns about this proposal was the security risk associated with permitting a potentially large flow of individuals without first undergoing biometrics and associated security checks. And the advice was that mitigations involving the valid international passport, the ability to check the validity of the Ukrainian government, and the use of an app capturing live facial image, coupled with wider threat picture from this cohort, meant that the risk was manageable. So that's entirely consistent with the evidence before the judge below. Now, I'm going to deal very shortly, still under the same heading of evidence, with the ending of the Ukrainian scheme. The supplementary skeleton and Ms. Naik's submissions have sought to make big points about the fact that the biometric concession for Ukrainians has come to an end. Now, of course, it only came to an end in December 2023, and for reasons explained in the witness statement of I've now got an embarrassing confession. It is indeed Mr. Armstrong, not Miss.
After all that.
I know, I do apologise. Mr. Armstrong, yes, that explained why it wasn't publicised, that the scheme was coming to an end in advance. So it effectively remained an internal document until the announcement was made. And my preliminary submission about this is there's a real issue about timing in relation to all of this and the relevance of this evidence. The judicial review, so technically the decision under challenge is December 21. Okay. Judicial review proceedings were brought in March 2022, and it has been accepted, and the case has been argued on the basis that things had obviously changed and they were able to bring their challenge to the difference in treatment between Afghans and Ukrainians. But there is something we submit inherently unprincipled in them seeking to make arguments about the circumstances in which a policy was brought to an end 18 months later, after the challenge was brought after judgment, And it,
Sorry, could you just start that sentence again? What is unprincipled?
to seek to make arguments about the circumstances in which a policy was brought to an end over 18 months after the challenge was brought, and surely that must be outside the scope of this appeal.
Could you just give us a close focus account of the events of the last month or two? So what were the sequence of events that led firstly to the disclosure? I think you've told us that.
Yeah, so if I can just, Mr. Justice Lieven's decision was, I think, February 2023.
Yes.
There was an application to appeal, and I think permission was granted in August 2023. In September 2023, there was a ministerial submission about bringing the scheme to an end, which was agreed, and the scheme was brought to a close. I think this is the 7th of December 2023.
Yes.
Right, so that's the background.
So that's the short chronology, and my primary submission is that all that evidence is not directly relevant to the appeal at all.
But you then, on top of that, there was the rectification of the disclosure issue.
Yes, so
which you brought about.
that's right. So there are two. The
Two
disclosure
strands.
has two aspects exactly. So the first relates to the March and April 2022 submissions, which I accept should have been disclosed before, which I've already explained. Those were disclosed, I think, on the 5th or the 8th of January.
8th of January.
Thank you, the 8th of January. And then, separate to that, in December, the appellant solicitors wrote to
Yes.
GLD saying, we hear the scheme's come to an end. And I think the correspondence is in the bundle. I don't
Yes,
have the
we have
page
got
number.
that.
We usually have.
So that was
The scheme has
was
come-
in the first strand. That followed from the first strand.
Exactly. So, in fact, although I can see why the appellant might think that their letter in December triggered this other the old disclosure from 2022. In fact, that in fact was not the case. It's just happened to be that way. Yes. So, in order to respond to what was being said, the questions are legitimately asked, bearing in mind, of course, that there are other proceedings or have been other proceedings afoot in relation to this. There was no reason not to give an explanation that was sought, and just to provide disclosure
So
of the ministerial
although
summation.
you provided Mr. Armstrong's statement,
Yes.
you did so on the basis that it wasn't really relevant to
No.
anything that concerns this court.
No. But in all the circumstances, it didn't seem right to say, well, it's not relevant, so we're not doing it, given that it was a reasonable request, and we could understand the reasons for wanting to understand, to know the information. It was actually an act of transparency, really, more than anything else. Now, I've just got a very few short points about, nonetheless, all of this anyway. Obviously, we don't dispute the circumstances have changed, which is why the concession was withdrawn. But we say it's primarily for the defendant to decide when the concession should be reviewed, and then what should be done about it. In my submission, the reasons for withdrawing the concession as recorded in the ministerial submission support the account that's been given all the way through and is consistent with the account of why the biometric waiver was introduced in the first place. The pressures on the VAC's no longer being there. The reason for the concession has ceased, and so it's been withdrawn. And the security assessment has also changed. So the key factor that always had to be balanced against the concession has changed, and that's set out in paragraph 4 of that ministerial submission in supplementary bundle 2 at page 49. And insofar as the appellant appears to focus on the reduction in numbers of Ukrainian nationals arriving within a month of partial application, and that's, I think, a point made today, but it's also in the supplementary skeleton. In my submission, that's just one factor. And actually, if you look at the figures, if you compare the various figures, surely those are only a point in favour of withdrawing the concession and not a point in favour of extending it to anyone else, for example. And whilst we're on evidence and disclosure, I've got a short point relating to the statement, the request for further information, the Part 18 document. And the short point is actually this. In my submission, the answers provided to the questions were all perfectly proper and aimed to grapple with the questions that were asked and aimed to answer them in the framework of the issues that seem to be under consideration. And there was nothing devious or wrong about what was done, and there's certainly no deliberate error in it. Right, could I then turn to the respondent's notice points?
So number 3.
Yeah, number 3. So analogous positions. I'm going to take this point shortly because I know that courts generally don't like this point and take the view that, you know, it should always all be looked at under justification. But actually, it makes a difference in a case like this. It's quite an unusual situation. It matters because of the impact of the shift in the burden of proof. And governments face a variety of crises arising both in the UK and around the world at any given time. And the implications of this challenge is that when faced with a fast-moving crisis, with or fast-moving situation with many moving pieces, and wanting to respond in policy terms to that crisis, that they will now be thinking, I'm going to have to, justify this by reference to very weighty reasons, or in a way that might actually end up putting a brake on HMG's desire to take some sort of humanitarian intervention at short notice, because the whole thing will then have to be justified and a considerable burden will be placed on the government for doing so. So if in fact we are right about analogous position, it does actually have a practical import. Now, the short point of law is set out at paragraph 59 of SC, which we cited in our skeleton argument. The page reference, if you want it, is page 324 of the authorities bundle. And I think actually paragraph 60 was wrongly sidebarred. It should have been 59, but that doesn't matter. That paragraph provides it's also necessary to bear in mind that not all differences in treatment are relevant for the purposes of Article 14. The difference is only relevant for the purpose of assessing whether there has been discrimination if the claimant is comparing himself with others who are in a relevant similar situation. Full stop. An assessment of whether situations are relevantly similar generally depends on whether there's a material difference between them as regards the aims of the measure in question. And we submit that the judge should have found that the appellant was not in a sufficiently analogous position to her chosen comparator, although the appellant's position is similar insofar as she is a person claiming to flee life-threatening risks in their country of origin, as would be the Ukrainians at that time. They're not in an analogous position when regard is had to the aims of the measure. And the aim of the policy to waive biometric requirements was to meet the specific problem of the overwhelming of vax in Europe, and the points that weighed against it, the concern about security, was assessed and not considered to amount to a block on this occurring. And that particular security assessment made it possible to suspend biometrics. And neither of those points apply in relation to Afghanistan. We've also said in our skeleton
Sorry,
argument.
so security not being a block, as you put it, that's not an aim, is it?
No, but
The aim is
the
to
aim-
meet the overwhelming of the vax.
That's right.
And you say that aim did not apply?
No.
Would not apply to Afghanistan?
No.
Was that can we pick away a bit? I feel I've been here before and I think I've come across it before on this particular issue. So can we just pick away a little bit? The measure in question, I think, is the requirement for biometrics, and that was then disapplied for one group and not disapplied for another.
That's right.
So that's the discrimination.
Yes.
But the aim of biometrics is not to relieve the pressure of vax. The aim of biometrics is domestic security, or whatever you want, knowledge
Yes.
about who's coming in. You then relieve it against one group for a number of reasons, but within that mixture is your concern about vax becoming overwhelmed, but you think you can mitigate that in one group.
Well, no. Your concern in that mixture is the security issues that you think you can mitigate it.
Yes,
with that
sorry,
group.
that's right.
Yeah.
But what drives you to think about it is your worry about overwhelming vax. So it's quite a number of things. I mean, it's too simplistic, isn't it, to say that you're relieving one group because of vax, which is what I wrote down your submission as being.
Yeah.
The aim of the policy is to meet the specific problem of vax in Europe. That's not really quite right, is it?
Well, it depends where you stand and what you're looking at. The aim of the biometric policy is overall security, if I can just put it in short like that. That applies to everybody. But that policy is not under challenge. So an exception was made for a particular group. Why? Were in order to meet the concern about the overwhelming vax. What was the aim of, if you ask the question, what was the aim of the policy to waive biometric requirements for Ukrainians? It was to deal with the problem of the vax.
It was to avoid. Overwhelming of the vax. That was the aim of the measure.
Yes.
But
I
was
think
it?
is
Yeah.
that the measure? It may just come down to this. What's my measure? What's the measure I'm looking at? Am I looking at the requirement for biometrics? Is the measure in question, and then it's relieved one, not relieved one? Or is the measure in question the relieving of the requirement for biometrics? And you say, well, why was that applied here and not applied there?
Well, in my submission, it's how I've put it, because I have to justify the difference in treatment between the Ukrainian cohort and the Afghan cohort. And the difference in treatment is the creation of an exception by the waiving of biometrics for that cohort.
Relieving them.
And so surely that's the measure.
That's the difference. So that must be the measure. Is the relief on the one's hand
Yeah.
and not on the other.
Andy, I mean, if your analysis was right, then there'd be no room for any equality law in this area at all, because the Ukraine situation was unique. And there weren't two Ukraines going on at the same time quite. So I don't see how this works. I mean, what was all this advice to ministers about equality? What were all these authorisations being granted for if in fact there wasn't going to be a comparator of any sort? It doesn't work.
But there is a comparator, of course, because the overwhelming of vax was as a result was by Ukrainians. So you had to exempt that group to prevent the overwhelming of vax, and that was not entirely by reason of nationality, because there are others that might be captured in the residence requirements. But that was the context.
So who would you? I mean, if your analysis was right, and you can forget people in Afghanistan because they're not in a relevantly similar situation.
Yes.
Then for whom was an equality assessment necessary with this biometric waiver?
In the provision of services under the Equality Act, the Secretary of State is not permitted to distinguish between people in terms of favourable treatment on the grounds of nationality or other protected characteristic. And so that's what it's for. It's for an Equality Act purpose. It's not done for an Article 14
It
purpose.
just seems that in the ministerial submissions, the officials, I appreciate not legal, but the officials were very much alive to the situation of people that they considered were in a relevantly comparable situation, apparently, that they considered they could justify it. There were grounds for doing so. So
I mean, obviously, I take your point, and you know, and no doubt, you know, Ms. Knight in her reply will make exactly the same point. And what's in the ministerial submissions is in the ministerial submissions. But I've already said that actually they're perfectly proper to take a careful approach, a cautious approach, and at the end of the day, that may or may not be right.
So what the only true comparator, if we can use that language, would be a nation where the numbers were so high that if they came in with biometric requirements in advance, VAX would be overwhelmed. That would be the comparator group on your analysis.
Yes.
So that would, and therefore, yes, okay.
Sorry, can I turn my back?
Is that right? Yeah, I think that's right. That's got to be right. Okay.
another Ukraine.
Yeah, another Ukraine.
Yeah, my junior is reminding me that you might also have an Afghan national in Ukraine who was resident before the relevant time, and he would also be a comparator for domestic purposes.
Because why? Because he was in Ukraine.
Yes, because the Ukrainian scheme doesn't just capture Ukrainians. In fact, it captures anybody who was resident. Sorry, I've got this wrong.
Sounds wrong to me. That can't be right. But you've got to be,
No, it's another Ukraine.
it's got to be based on nationality. So wherever you are, if you're Afghan, for these purposes, the biometric requirements.
Right, I see.
Yep.
I see. Sorry, I've got that wrong. If I could just start again. An Afghan national in Ukraine would not benefit
No,
from the biometric waiver.
because it's all about nationality
And residents.
and
And residence at a certain date.
Yeah.
Yeah, because not all Ukrainians can benefit from it either.
People who are not resident can't
Correct.
in January
Yeah.
22.
Exactly. Yes.
We're about to come on to that.
Yes. Well, so we put it in an slightly alternative way in our skeleton as well, which I don't think I will state out loud, and I've got nothing to add to, but that is which compares the two schemes as being different, but that's all I wanted to say about analogous situation. Could I then turn to Respondent's Notice Issue 2, which is the standard for justification? Regarding the standard for justification, so the very weighty reasons test comes from Gegesus and Austria in 1996. That's in the authorities bundle at page 609, tab 20, which is then repeatedly cited in other cases. This case concerned a Turkish national who was legally resident in Austria, had worked and contributed to the national social security and had applied for emergency assistance. He was denied it because one of the criteria was that you had to be Austrian, and page 613 sets out the national provision. The judgment starts at page 624, and the relevant part is at 626, paragraph 42.
So this is pure nationality.
Exactly, exclusively nationality, in fact. We'll just pick it up. Yes, so paragraph 42 on page 626 is it's the last sentence. The rest is cites what everybody already knows. Very weighty reasons would have to be put forward before the court could regard a difference of treatment based exclusively on the ground of nationality as compatible with the convention. And it found that it was not.
Sorry, I've just gone blank. Paragraph.
Paragraph 42. The last sentence.
I mean, it's not a very user-friendly phrase, is it?
No,
Varies and weighty and
it isn't.
anyway, it's been adopted. I know,
It's
followed
been-
in the cases.
And paragraph 50 just demonstrates that in that case, the court held that it was not based on any objective and reasonable justification, so the claim succeeded. Now, the same test is repeated in Andrzejeva and Latvia, which is page 655.
Does it say anything more than that?
No, but it doesn't, but it repeats exactly the same phrase exclusively on the grounds of nationality. But it's relevant because it was a case concerning pension calculation following the dissolution of the Soviet Union. And the relevant paragraph, just for your note, is paragraph 87 on page 682. And then I'm going to come on to the last case I want to refer you to, which I would like you to turn up, which is Savikis against Latvia. And that is at page, I don't know where it starts, give me a second. Oh my goodness.
26.
Thank you. But the relevant part of it is paragraph 193, which is on page 823. Now, this was another case concerning social security systems created which did not take into account employment in other territories of the former Soviet Union if the person was a permanent non-resident. And that's the same situation as the Andrzejeva case against Latvia, where they had found that where it was, and because it was based on exclusive nationality, very weighty reasons required, and these were not met. And the matter came up again.
Can I just query, why are we going through this litany of cases which all say exactly the same thing?
No, because this case is the first case, and it postdates SC, so it really emphasises what the Supreme Court. It's the first case where the court holds that the specific circumstances of the case are to be taken into account in determining the scope of the respondent state's margin of appreciation. Because, of course, up until now, if you had a very weighty reasons requirement, then you'd have a correspondingly much narrower margin of appreciation. And in this case at 206,
So that's what is said in SC.
yeah, in page 206 of the Grand Chamber in Savikis states,
Sorry, I've lost my bearings. I'm on page 823 of the bundle. Is that where
827, please.
Thank you.
My apologies, I'm not
Right.
looking.
827, 2 para 206.
And as my lord says, that's exactly what paragraph 103 of SC says, which is the fact that you've got a requirement for very weighty reasons doesn't exclude the possibility that there's a relatively wide margin of appreciation and a correspondingly less intense standard of review.
But this case, which postdates that, is an example of precisely that, where a
Right.
very wide margin is
Well,
given, notwithstanding that it's
pushing
on
an
basis.
open door here because Ms. Nagy
Right,
is not challenging that you have a lot of elbow room.
Fine. Well, in in that case, so, you know, that's so.
But I thought your point that here was all about paragraph 108 of SC. This is the challenge to the notion that the very weighty reason requirement is limited to cases where the exclusive reason is nationality. And you say here it was a strong reason, but it wasn't the only reason, and therefore the very weighty reason requirement doesn't apply.
That's correct. That's
And I understand the appellant to respond to that by saying, No, look at para 108 where it's sort of watered down, or exclusive is equated with to a decisive extent.
Yes, and
That's how I understood the argument that was
that's
being
right.
run.
And that is true in that, but only of race and ethnic origin. So paragraph 108, which says that and relies upon Bow and Denmark, is a case about race and ethnic origin.
Why is there a
not
principal difference? What is the difference in principle with nationality?
in my submission, race or ethnic origin is seen as more suspect than nationality. And indeed, there have been statements where courts have queried whether it might ever be possible to justify a discrimination or difference in treatment on the grounds of race or ethnicity, but that's patently not the situation in relation to nationality.
Right.
In the event that the appeal grounds were not to succeed, and I appreciate you've yet to come to them,
Yes.
should we really be saying anything definitive about this, bearing in mind that it would not be part of our decision?
You may well feel that you don't need to.
I mean, I can see that you don't want something sitting in the law reports that might be taken elsewhere and said that this has always got to show very weighty reasons because the judge did in this case. But that apart, speaking for myself, it strikes me that this is all a bit fringe. So if the appeal was not to succeed in its own terms.
Yes, I mean, obviously, I see all that. I mean, it was always accepted there was a difference between the first point and the second point. That the second point actually, even if we're right, so what?
But I'm confused now, and it's all my point. Are you, my fault, I suspect, but are you saying that there is no very weighty reason requirement because this case was not a case exclusively based on nationality? Nationality just played a part of it, and the test is exclusion? Or are you saying, well, the test is very weighty reasons, but you give a very wide margin of deference to the assessment of the government? Or do you say both?
Both,
Right.
Absolutely. So on the facts, the test for very weighty reasons is if it's exclusively based on nationality. It wasn't. That's limb 1. If I'm wrong about that, then you, even if it's a very weighty reasons type case, you can still, if the area of the field in which the decision is being taken is one to which great deference is due to the decision maker, then you can then there's still a wide margin of appreciation.
And we cut you off, you say 26, the authority at 26, Savicus is important because it's post-SC and it tells us at paragraph 193,
No, 206.
tells us at paragraph 206 that what?
Let me go back to it. That even the assessment of what may constitute very weighty reasons may have to vary in degree depending on the context and circumstances.
Right.
So that's something a bit different from deference, or is that the same thing as deference?
It's the same thing as deference in the real world.
So that backs up your second point.
Yes.
Right. And then grounds of appeal?
Yes. So ground 1 is that the judge failed to adequately engage with the detailed and specific case on justification, finding in terms that were too short, engaging only at a high level of generality. We say the judge was not required to engage with the case in any more specificity than she did, and her reasons are sufficient and the approach was correct. We would point you to paragraph 32, where she records the nub of the complaint.
I mean, in fairness to you, this point actually hasn't been pressed at all orally. Or how many is it?
not-
Last warning. Anyway, yes, you say 32 of the judgment deals with it.
Yeah, totally correct. She summarises the evidence. There's no dispute about those summaries. That's at paragraph 32 to 34. And at 39, she states that the significant weight or a wide margin of appreciation should be given for the reasons put forward. And I just want to say this is correct as a matter of principle and give you a couple of references. Matters of immigration control engage macro political and socioeconomic considerations and potentially national security issues, and all of that, those are matters that fall within the competence of the executive.
This is Raymond and Al-Rawi.
Exactly, Raymond, Al-Rawi, KA as well, which is page 186, sorry, paragraphs 186, 189 and 190. And the context also engages questions of international relations. That's the Al-Rawi point. Then you know that you've also got SC, which accepts the wide margin, even in areas that might require more reasons, weighty reasons, and Saviki's that is the same. And then at paragraphs 41 to 42, she addresses the specific justification for not treating Afghans in the same way with regard to biometric data waiver. She concludes that the biometric policy, as applied to most of the world, including Afghanistan, has a rational connection to the aims to be achieved, namely immigration control and national security. That's clearly borne out by the evidence. And then she deals with this justification for not creating a similar exception for Afghans from the biometric policy. And in my submission, she was entitled to accept that there were good reasons for the biometric waiver for Ukrainians. And she was equally entitled to accept that the national security context was raised more strongly in relation to Afghanistan than in relation to Ukraine. And so in my submission, there's no error in approach at all. And she dealt with it as summarily as was permissible. And what needs to be remembered, of course, is that the reality is that this is an attack on the waiver of biometrics as a policy, rather than, although she says obviously it applied to her, so it had an impact on her, but an individualised decision could be made and had been agreed to be made as to whether or not her biometrics should be waived for the purposes of her application. And that's where the individualised assessment comes in my submission. And that's not within the scope of this appeal, what's occurred in relation to that. I am unclear as to what the distinction is really between grounds 1 and grounds 2. But we have set out our response in relation to that in our skeleton argument, but in broad terms,
essentially, sorry to talk over you,
yes.
when your main point arising out of your previous submissions is that, in a sense, neither ground is in play at all. Because that's not, if one was to treat the grounds as being the limits of the discussion, which may not be the right thing to do, actually the discussion is about something different, which is about the lawfulness of the authorisation. Yeah. And we've heard something about that, so we understand that issue, but it's not congruent with the grounds.
No, well, we've answered the point in the written case in our skeleton argument in my submission, but unless there are any other questions or a point that I haven't dealt with.
No, thank you very much indeed.
Can I turn my back?
Yes, please do. Yeah.
Thank you very much.
Thank you. Yes.
Thank
Snake.
you, Lily.
Mm.
I'll just come back to that grounds point first, which is that, and I think that's why I just came, when I came back after lunch, I just came back to have the remedy that we sought in our skeleton argument, which was a declaration that was a breach of Article 8 read with 14 on the basis of the difference of treatment as regards biometric enrolment. That is the core of what we are concerned with here.
But isn't it right? I mean, having got to the end of the day, that really your arguments have been really not focused on the two grounds of appeal at all. They may be going for that. It's not necessarily criticism, don't worry. I'm just trying to make sure I understand the arguments. It seems to me it's all been about what's the test, and did the judge, not least because she didn't have all the information, you say, in concluding there were very weighty reasons. That's been the thrust of the argument.
I mean, that has been the thrust of the argument, but I just want to bring it to the grounds because although I can see, obviously we set out my opening statement to the court was that is the discrimination justified or the difference of treatment justified. That's what we're inviting the court to determine. Where in our grounds we said the court was required, and I just want to break it down. Was required to address with a greater degree of specificity her central submission that the discrimination wasn't justified on the facts of her case as an Afghan national seeking entry outside the rules. I mean, I've gone on to talk about the flexibility of biometrics, but full stop there, i.e. no very weighty reasons. That's really what we're talking about.
Okay.
And the second question about individualised assessment is look at the comparator, i.e. the individual assessment isn't just an Afghan national seeking entry. It is an Afghan national who's seeking entry who can't get to a VAC because it's dangerous and they're seeking to join their family member in the UK. So that's how I've, maybe that's a little bit creative, but that's how I have.
Well, I don't think anybody's taking a pleading point against you. And the important thing is you understand your argument.
I'm grateful,
But I think, yes.
Yeah, so that's how we put it. The second point was in relation to the ministerial authorisation, and I think I'm right to correct myself as saying it wasn't the pleaded target. The pleaded target was the discrimination, which is demonstrated by the series of documents we have, which was the various ministerial submissions, the change in the immigration rules. That's why we included in that supplementary bundle the explanatory statements.
Right. So what is the pleaded target?
Which is the difference of treatment, which is manifested in a series of ways, including the ministerial authorisation. But but prior to the formal ministerial authorisation, there was a ministerial agreement that was set out in the policy documents we looked at. I don't have to go back to those, but from the 14th of March, and there had to have been because the immigration rules which allow for the biometric deferral couldn't have been laid without that ministerial agreement. So that all happened before the formal authorisation took place. I just, for the purpose of the, I just give you the bundle reference for that in the additional authorities bundle, tab 1, explanatory memorandum, which is at 7.5. and 7.1, which is that's dated March 2022, allows for people to start their applications without and completing them by providing their biometrics in the UK. That's not a ministerial authorisation under the Equality Act. That's just action taken by the Secretary of State for the Home Department in the global sense. There is but what comes is the ministerial authorisation, but that's not the only target. And what I finished it before lunch, I've corrected after lunch as my declaration statement. So I hope that's clear. And we do, I realise that the actual section 17 of the Equality Act isn't in the bundle. I can happily hand those copies up just for sake of convenience. Because, sorry, paragraph 17 of Schedule 3, which you should have for completeness. We accept that there needs to be deference. That's consistent with Al-Rawi and Remen. We put Begum in the bundle, the supplementary authorities bundle, again for completeness because it's more up to date and because there's still the emphasis in a human rights focused case for the court to to evaluate that question. So again, deference is not a conclusion, it is just a fact, it is a factor.
But Begum, sorry, I've lost the thread, but that wasn't a discrimination case, was it?
No, but just in terms, the Secretary of State in her skeleton argument at paragraph 79 has one line, which is, perhaps I'll just go to it, which is, and then a footnote with a series of observations. The same judicial restraint applies to measures involving national security and foreign policy. That's her case. She sets out 78 in justification, Lord Reed, SC 115. And actually, my understanding of the Secretary of State's case is in that, as the margin, is in paragraph 79. And there she refers to Remen, Begum, Al-Rawi, and I just wanted to put those, Lord Reed, Begum at paragraph 70 into the bundle so that it doesn't, I mean, this court is not going to make that kind of mistake, but to emphasise that in a human rights case, it's the court's got to decide the question for itself, even though there is a deference and a margin of appreciation.
Ooh, are we in danger of getting in a real muddle here? Because a proportionality question, yes, we do decide that for ourselves, and there's a lot of case law about first appeals and subsequent appeals, and what's the measure of review and so on. I don't think that's this case. This is a discrimination case, and what we're talking about is the margin of discretion. So you have to be careful about how that, and that's why Al-Rawi and Begum and all those cases are interesting, because they're national security cases,
Yes.
and the court has said that others possess institutional competence and democratic accountability.
Yes.
That's the point we're on, isn't it?
I mean, I would agree with my lady that the point is that the Secretary of State has put that in her skeleton and she's relying
yes, but
on
not
it.
in the way you're talking about it. She may, I don't see any difficulty speaking for myself with paragraph 79 of the Secretary of State skeleton, where the proposition is that when you get to cases involving national security and foreign policy, deference is owed to the executive.
Yes.
Anybody will
No,
say that's the wrong thing to
which
do.
is what the proposition.
No, what you said was that we as the court have to decide this for ourselves because it's a human rights case. And with respect to you, I don't agree with that. I don't think that's the right approach.
Can I just go to Begum then? Which is at tab 3 of the additional bundle of authority.
Yes, paragraph.
70.
70.
70,
Yeah.
sorry.
That's all right.
I mean, it is, I suppose there is obviously a contextual difference because those are judicial review claims of an action by the Secretary of State on judicial review principles in accordance with the, albeit that there's an HRA context. So I can see my ladies.
This is all about SIAC. That's the context for this.
Yes.
And what a right of appeal means.
Statutory appeal.
Statutory appeal.
Because
71, it says SIAC has important functions on an appeal, and that deals with, perhaps go back at the end of paragraph 70. SIAC has to bear in mind in relation to practice kind of Secretary of State's assessment should be forward with respect, reasons both of institutional capacity and democratic accountability, the point my lady was making, as explained by Remen by Lord Bingham there, and Lord Bingham in A. Actually, sorry, it's the passage was at the end of 69. It was, if a question arises as whether the Secretary of State has acted compatibly with the appellant convention rights, contrary to section 6, SIAC has to determine that matter objectively on the basis of its own assessment. That was the passage I was intended to come to. Apologies for going backwards to it, but that's the question. The question that arises is whether the Secretary of State has acted compatibly with the appellant's convention rights. That's a question that SIAC has to determine objectively on the basis of its own assessment. So that's why I used the language that I did.
All right, okay, well, that's helpful. That's where you've got it from. So we can work on paras 69
Yes.
to 71 insofar as
Um,
we need to.
And so that's why we, that's how I respond to para 79 of the Secretary of State skeleton. Just coming to where the Secretary of State's point on the policy document which Miss Broadford started, which was the unable to travel guidance. It is new guidance. There hasn't been guidance like that before. There is a general guidance about biometric policy and the importance of that, and then that was judicially reviewed in the case of, don't have to turn it up, but it's SGW tab 11 in the authorities bundle, and that was then amended to the general policy to provide for reference to the exercise of discretion. But this policy is the policy that emerged in the course following these proceedings, and where, as you can see from Mrs. Justice Lieven's judgment, you'll see her reference at the end, which is at the end of her judgment, where she invited the Secretary of State to file a note. Sorry, is there no reference to the judgment? Anyway, then she asked the Secretary of State to file a note about what would happen next on the question of biometric deferral consideration. You have that note. It's at paragraph, supplementary bundle 1, tab 8, page 173. And in that, this is all prior to the unsafe, unable to travel guidance being published. And in that note, having said that the decision was under consideration, and bearing in mind Mrs. Justice Lieven's observations about if the Secretary of State hadn't agreed to consider that she might have approached the case differently, which is what she says at paragraph 45 of the judgment. The Secretary of State is now considering deferring until the in-principle decision is made. It's not at the time live. Secretary of State then, a couple of days later, after the judgment, filed a note which said, paragraph 16, she can't indicate at the time scale, preparing specific guidance in relation to biometric waiver on the grounds of journey to VAC would be unsafe. Don't know exactly when it will be. And importantly, this goes to the very weighty reasons point and the blanket authorisation of biometric deferral. A decision to refuse to defer can be taken by a caseworker. But a decision to defer, that's either in any individual case or blanket, requires ministerial approval. So that's what the reality of the guidance means, which is why we come back to very weighty reasons. The Secretary of State has authorised biometric deferral for 200,000 plus people, but if she wants to authorise it in any other case, it has to be on an individual case-by-case basis. And that's why we say, when we're looking at the impact of the measure, that we say that bearing in mind that impact, we say that doesn't deal with the difference of treatment with reference to very weighty reasons. And just one other point in relation to the way Miss Broadfoot put the case about the justification being overwhelming the VACs. I mean, the overwhelming of the VACs occurred because of the implementation of the scheme, the broader scheme. So we say that it's not part of our case that she should have implemented a scheme for Afghans who have families in the UK. But the justification given is that now that we have implemented this scheme, we thought everyone would give their biometrics. Now we realise there's going to be 200,000 people and the VACs will be overwhelmed. We're going to have to defer.
So what's wrong with that?
So
Why does that
well, that's
matter?
why we say if you look at the impact of the measure on the group who are treated differently, we say, well, that's not very weighty reasons. That's a situation created, we say, by the Secretary of State.
Can I ask you something related to this? I've just been thinking, what is all this now about?
Yeah.
That you told us that you wanted a declaration.
Yeah.
That the lesser protection of family life for Afghan nationals compared to Ukrainians constitutes unlawful discrimination. Now, I understand that at the time, way back,
Yes.
when you started on that argument, things were very different. But since then, you've had the judge's decision. You succeeded in getting permission to appeal. The judge's decision was a year ago.
Yes.
You succeeded in getting permission to appeal in the summer. Now, here we are in 2024, and the policy about which you are effectively complaining has been withdrawn.
Yes.
So, I mean, in the end, what is this about? I mean, you're asking for a declaration that you were discriminated against. Is that it?
Yes. Well, until
In a sense, what
What does it do?
what good is that to anybody? I mean, I appreciate that you're here because you've got permission, so I'm not complaining
so,
about that.
my lord, we did review the question about the appeal in light of the disclosure that we got in light of identifying that the policy seemed to have come to an end
Yes,
and
I
asking
mean, it all
for,
seems now to be completely
for-
moot.
for
to
the
be honest.
reasons that we set out.
That it's not. I mean, I understand the severity of your client's position as she describes it, but really the caravan has moved on in this case.
Well, my
And-
lord, I hear what you
And
say.
I'm just throwing that at you so you can
So-
explain why, in a sense, it really does matter that you get your declaration.
Well, Lord, we say it does matter that we get our declaration because for the reasons that we've gone through in terms of the evidential support or the case advanced by the Secretary of State for making the ministerial the ministerial agreement and then the positive discrimination under the immigration rules and then the statutory authorization and then continuing that until very recently. The evidence that we've seen both at the time and at the time of the withdrawal, that all require this court is now well placed, having heard arguments and seen the evidence, to determine whether there were very weighty reasons.
But we understand all of your arguments, but that isn't an answer to my lord's point. What is the practical purpose? What happens if we say yes for 18 months or whatever the relevant period is? There was we declare there to have been unlawful discrimination.
Well, my lady, even if the practice was still going on, the declaration would only ever have limited effect because it's for the Secretary of State to then decide
Yes.
what
Yes,
to
but
do.
it's
and
of
how-
no effect now.
Because you can't. I mean, you can't now have a Ukraine-like visa biometric deferral because even Ukrainians don't get that.
My lord, I accept that, but as my lord will also observe, we have these what were parallel proceedings until they very recently settled in terms of the
So
challenge
you
to the
feel that the
individual.
declaration would be, as it were, grist to your mill or power to your elbow in relation to other proceedings yet to be taken.
But in this case,
I mean,
it does raise.
Is that what this is about? By now.
Well, my lord, this is very swiftly changing picture because we got the new decision on I think it was the 8th
Well, I
of
understand, but
January.
it was open to you, obviously, saying, well, now we've got to this point, actually, we needn't trouble the Court of Appeal about this. We can focus our efforts on more pressing.
It's right to say
business.
that we did consider those. We didn't just not have any turn our mind to those questions, but we say there's even applying the Salem type principles on academic appeals, if that's where this
Yeah,
submission
that's where
needs
the
to
submission
go,
would go.
then we say there's still an important point of principle for the court to determine that, which
And in
is
fairness, Miss
Hasn't
Broughton's
made
not
that
taking
point.
the point against
No.
you.
no, indeed, that's right. But it's an important point of principle for the court to determine whether there were very weighty reasons to justify discrimination on grounds of nationality. I note in the Hodder case, for example, that went to Strasbourg, by the time that case got to Strasbourg, the minister had already changed the immigration rules because there'd been either because there'd been an earlier finding of discrimination or because the minister thought they're going to lose. So
Yes.
that it wasn't live. And I think in some of the other discrimination cases, that is the case. But we do say, the court knows very well the Salem principles, but this type of case, raising these types of very sensitive issues, if I can put it in those terms, not least because we also have potentially the closed material point as well. That's a reason why this court should determine the appeal.
All right. That's
in
very
open
helpful, thank
and
you.
if necessary enclosed.
Thank you.
Thank you, Ms. Knight.
Thank you, my lord. And just if I may check.
Yes,
whether
please take your
the
time.
defendant,
So what I'm going to suggest as we rise, I'm going to flag up the sort of question we might ask when we come back in. Are you happy with that? Happy with that?
Yes, I mean, I don't think I need to deal with the analogous position. I think your court's given fairly clear indication on that. Yes, we dealt with that paragraph 49 of our skeleton. I just wanted to look at one final point. No, I think those are the points that we wanted to raise in reply, so in open, and then I'll leave the rest in the court.
And we haven't had time to hear from anybody in the second row, which I'm very sorry about. I could see that we were under pressure of time. I hope you're all aware of the indication we've given that we would like to hear from junior counsel whenever possible. But I took the executive decision at about 3 o'clock that I wouldn't press anybody on that. But perhaps another day, we would look forward to hearing the oral advocacy of those behind you. We have certainly had the benefit of their written advocacy and, of course, the support of those behind all of you in the row behind that. So thank you all very much for your submissions. Now, Mr. Cragg, we are going to retire now for perhaps 5 minutes or so. We're going to stay in open and we'll come back into court and give an indication of what questions, if any, we have in terms of going forward. It may be that the sort of question that we would like your assistance on and your assistance on, Miss Broadfoot, given that you are also aware of what's enclosed, but to underline staying in open. Having heard the submissions today, do either of you wish to submit that it is necessary for us to go into closed? Now, it may be you can't answer that question, and the answer is I simply can't say. But will you have a think as we retire now as to whether or not you can assist the court?
Yes, I mean, it's Ms. Broadfoot's application under section 6. So.
Yes, absolutely. But you may have a view because it depends what's in there. And I say we're staying in open. I see no reason not to go into closed at this stage to give us a steer. And then we may have some further observations to make that will assist that process. But if we can aim to come back in or be ready to come back in after 4:05, from then on, that will be very helpful. Yes, happy with that? Thank you very much indeed. Thank you.
We're still running. Thank you.
Raise that point back now. I mean, they weren't really I mean, but well, just as well we had it before. to know and everything.
That's note 172.
The live stream. Oh, the live stream's still on, sorry. Just tell them when they come in, the live stream is still on.
Thank you all very much indeed for waiting. Miss Meg, will you forgive me if I address myself to Miss Broadfoot and Mr. Cragg in the first instance? Obviously, we haven't reached any final decisions at this stage. We are troubled to a degree about the potentially academic nature of the appeal, and we need to decide how best to move forwards and whether or not we need to make directions for a closed hearing. To assist us in that process, could we just ask both of you the following question? You first, please, Ms. Broadfoot. Given what you know in the closed material, is there anything in there that you, discharging your duty of candour, consider might reasonably assist the appellant in the arguments that she's advanced today and in writing in support of this appeal?
I don't think I can answer that question in open.
Right.
I'm sorry.
Mr. Cragg, can you answer that question in open?
I don't think I can do either.
All right. Is there anything either of you would like to say in the light of today's oral submissions on the question of whether or not there should be a closed hearing?
I think the problem that Ms. Broadfoot and I both had is it's very difficult to say anything at all on that issue. We could make short submissions on that issue, close. It's difficult for us both, I think, to address it in open.
Yes, well, I think in those circumstances, perhaps the sensible thing to do, subject to my lord's views and my lady's views, is for us to direct that you should each, please, within the next 7 days, submit written arguments, short written arguments, on the question of whether or not a closed hearing is necessary, and closed arguments, absolutely, closed arguments as to why or not, on what issues you think that we might be assisted, and we'll take it from there. I'm sorry, Miss Naig's always an uncomfortable position for you to be in, but I've gone as far as I can in open, so it would appear, and I think taking it forward in writing is probably the best way forward. Now, I don't know what you think about that, Ian.
That's the next step.
Yes. Yeah.
Unless the court wanted to go into closed now, but I don't know if it can at such short
I think
notice.
I don't know whether we're in a position to go into closed right now. No, I think we're not quite there. And I think doing it in writing, we'd have to go and consider together in any event. And I think now's not the right time of day to go down that road. Yeah. I think if we're going into closed and having written submissions, at least in the first instance on this, then feel free to say anything you want. You know, to what issues would it go? But we would be particularly interested, you know, how might it help the respondent?
Yes.
How might it help the appellant? What is the relevance of the material?
I think Ms. Broadfoot and I might be able to assist if we have a discussion as well. So,
Yes, absolutely. Discuss away. That's always welcome. Make sure you're somewhere closed. And if you can produce an agreed document, so much the better. Ms. Nick, yes.
Melody, I wonder if because of the point on academic appeals being raised late in the day, but I wonder if I might just file a very short note on why we say the appeal isn't academic against the principles, unless the court. I understand the court was thinking of that.
We're not going to. I'm speaking of provisional views. I don't think we're going to dismiss the appeal on the basis that it's academic. It's just a matter of concern in terms of case management and where we go forward. Obviously, the substance is important, but we need to be alive to the realities of the situation, I think, at the same time in deciding where we go.
Yes, that was just one of the principles about if it's in a good reason in the public interest for hearing the appeal and now for determining the appeal, we say.
Yeah. Is that your main point?
Yeah, just looking at Zoo Life and Salem.
Zoo Life,
Zoo
yes.
Life in the
Yes.
2008.
Yes.
It's just a silver.
Yes.
Yes.
And just the final point, just to avoid any confusion, my point on deference was only in the context of national security as pleaded by the Secretary of State in her skeleton, not the margin of appreciation point is the point we advance as per SC 115. Just that the point on deference was raised by the Secretary of State in the skeleton argument specifically about national security and foreign policy, and that may or may not affect matters that go in closed, but I just wanted to raise those here and live to my Lady Justice Whipple's point, in case there was any confusion about where my submissions were going.
But what I've written down is that SC is what we
Yes.
take as our script
I think that's absolutely sensible. I've got copies of the Equality Act if anybody wants that section for the bundle now, if they don't.
Yes, no, absolutely.
Oh, yes,
No,
I'll
that'd be
have
very
those,
helpful.
thank
Thank you. Thank you for all the hard work. Mr. Cragg, is there anything else you'd like to say at this stage?
No, not at this
No.
stage. I think my role is always holding close.
No, all right. Well, thank you very much indeed. Anything else?
Thank you.
No. Well, it's been a pleasure to see you all. Thank you very much for your assistance. I should say, of course, we'll reserve our judgments, depending on where we go with the closed material, subject to the usual embargo. But we may have an intervening hearing between now and then. Thank you very much indeed. Thank you.